Welcome to my channel, All for Health with Jane. Family, on this video, we are going to watch and listen to the responding affidavit of accused number 4 in the AKA and Tibz Motswani murder case. Accused number 4 by the name Gwabeni. Family, much as Gwabeni does not have any pending cases and previous convictions, the affidavit of the investigating officer places Gwabeni in different places on the day AKA and Tibz were murdered. You know, family, it places him at the airport using the cell phone location, of course. It places him at the airport. From there, he's seen following AKA's car. It places him at the hotel where AKA was booked. It places him at the vicinity of the crime scene. And again at Umlazi, family, around the same car that it is alleged was used for the offense. Gwabeni is placed at all those places. For him to distance himself from the killing of AKA and Tibz, it's not going to be easy. But anyway, it is the duty of his lawyer to poke holes into the case, the state's case, until the state case is seen very weak. That's their role anyway. So, family, let's go back to the 800,000K. Remember, the 800,000 that was deposited into Gwabeni's banking account. So he says that 800,000, if it was meant for the killing of AKA, why is the same person who deposited it, why is he not arrested? That's the argument that Gwabeni is giving. Why is Mfundo Xaba still outside after the case, the state has realized or maybe discovered that Mfundo Xaba is one who deposited the money into his account? He says, why? Why is he not arrested? Family, to me, I think this is a lousy argument because, you know, the state does not just arrest a person. It has to go, you know, in a long process before a person is being arrested. The NPA or maybe prosecution department, those are the people who must ensure that they do their investigations until they are satisfied that this person, and do whatever processes they need to do. Once they are satisfied, then they can give an instruction that this person must be arrested. So Gwabeni further admits having a grey BMW and silver Polo that he does not deny. He says, yes, indeed, I did hire those cars, but it was many months before, about 10 months before AKA and Tibz were murdered. He denies following AKA from the airport, and he requested the state to provide the CCTV footage of him following AKA. Meaning, if you say, I followed AKA, then I want evidence. Give me a CCTV footage where you have seen me inside the car driving behind AKA's car, which is not going to be easy, of course, because what the state has, it's only the evidence that was given by from the cell phone location or tracking system. So family, let's listen to Gwabeni's new lawyer as he presents Gwabeni's responding affidavit to the court.
It pleases the court, your ship state is recalling case number 23 2156 of year 2024, State versus Lindani Mkwanazi and 4 others.
Thank you. Thank you, Mr. Jurgensen.
For the indulgence, Your Worship, can I hand to Your Worship the original reply and affidavit of applicant number 4? Your Worship will note that with that affidavit are confirmatory affidavits, as well as a USB from which the stills which are attached to the affidavit were taken. My learned friends for the state have been furnished with a copy of all that I've outlined to Your Worship.
We have received same.
Now,
You
thank
may
you.
proceed. Thank you.
This is the reply and affidavit of applicant number 4. I, the undersigned, Mzwithemba Harvey Gwabeni, do hereby make oath and state. I've read the affidavit deposed to by Kumarasan Pillay and respond thereto as set out hereunder. My failure to address each and every allegation should not and must not be considered to be a tacit agreement on my part. It is not my intention to repeat what I've stated in my founding affidavit, but simply to address those aspects of Pillay's affidavit which I believe deserve attention. A critical reading of Pillay's affidavit should, I believe, lead the reader thereof to the conclusion that the state's case against me consists of the investigating officer taking bits and pieces of evidence which he believes is suitable to his case, joining them together with his own theories and thereafter presenting them to this court. In so doing, he has attempted to mislead this court and has departed from his duty as an investigating officer to investigate objectively by leaving out evidence favorable to me. The immense problem that the state has in this matter, and which can be described as the elephant in the room, is the status of Mfundo Gwaba and the failure on the part of the state to arrest him. The state has alleged that I am the mastermind behind the killing of Kiernan Forbes, AKA and Tibz, and that an amount of 800,000 rand, which was transferred into my account, was payment for the so-called hits. The state has alleged that the transferring of the funds was payment for the shooting. In this regard, paragraph 71 of Pillay's affidavit refers. According to company records, Mr. Sidney Mfundo Gwaba is the sole director of this company. When the money was transferred, a reference was used as consult. This, we are of the view, was done to disguise the nature of the funds, as same is viewed to be payment for the shooting. If the state honestly believes this, and if it had any evidence, not conjecture, then I would have expected that Mfundo Gwaba would have been arrested and would have been a co-accused. The fact that he is not a co-accused and the state has not taken this court into his confidence and disclosed why they have chosen not to arrest him. As I've stated in my founding affidavit, I'm involved in the coal mining industry and consult to various parties. The reference accompanying the deposit of 800,000 rand into my account, namely consult, is corroboration of this fact. It is not the function of this court to simply rubber stamp that which the state desires, and in fact the law, when it comes to bail applications, encourages a presiding officer to adopt a more inquisitorial manner. As such, I believe that the question this honourable court should be asking is why exactly has the state failed to arrest Mfundo Gwaba? I submit the answer to the said question is because there is no evidence against him, save for the payment of 800,000 rand into my account for services that I rendered to him. Just as the state has been unable to tell this honourable court what possible motive I could have in the killing of Forbes, so it is that the state cannot inform this honourable court why Gwaba would want Forbes and his companion killed. The reason for this is simple, and that is that neither of us are contract killers or wish to see them dead. I address those aspects of Pillay's affidavit that deserve attention hereunder. At para 9. Pillay alleges that I was at the airport and that I used my phone to pay for parking using a virtual bank card. If he had investigated properly and objectively, he would have noted that my wives and those who do work for me are also in possession of a virtual bank card linked to my account. A virtual bank card and the allegation that I was at the airport around the same time is simply insufficient. It is insufficient, and it is also based on cell phone triangulation, which at best puts an individual within a 10-kilometer radius of any particular object or building. The state has been strangely silent and has chosen not to address the fact that an airport is a national key point with extensive security and closed-circuit cameras. As such, had I been the driver of the grey BMW on the day and time in question, I would have expected the state to state categorically that they have video evidence of me driving the motor vehicle and following Forbes. The fact that they have not stated this is an indication that they have no evidence that I was driving the grey BMW or even in the said motor vehicle. As I've stated from the onset, it is no secret that I was in possession of the grey BMW as well as the grey VW Polo. It is alleged that, upon further investigation, and using cellular phone records, it was established that applicant 4 was present in the grey BMW that had followed the first deceased and his entourage to the hotel. The state does not take this honourable court into its confidence and disclose the investigation, and its vague reference to cellular phone records can only but mean cell phone triangulation. This on its own is insufficient, and I'm advised that there is case law which comments critically upon the reliance of cell phone records. Ad para 18. Although the purpose of my deposing to this affidavit is not aimed at defending my co-accused, it is necessary to point out certain allegations which I believe are indicative of Pillay wanting to mislead this honourable court. An example of this is that the clothing of the person that alighted from the vehicle and entered the restaurant was the same as seen in the video footage as being the African male that was later identified as applicant 5. It is significant that Pillay does not describe the clothing other than a vague reference to it. An example of this is 2 individuals who both wear long pants and a long shirt. They would be seen to be having the same clothing, according to Pillay. Ad para 26. Another indication of this is the allegation that one of the suspects who attempted to set the Mercedes-Benz alight purchased airtime from a tuck shop a few meters from where the vehicle was abandoned. This honourable court is not informed as to the date upon which the Mercedes-Benz was allegedly attempted to be set alight, as well as the date upon which one of the suspects allegedly purchased airtime. Ad para 27. Once again, reliance is placed on cell phone triangulation, and the allegation is made that I was in the vicinity of Florida Road at the time of the shooting. Whilst I cannot recall my exact whereabouts, Florida Road is considered one of the premier night spots of Durban, with notable restaurants such as Zai, Al Cubana and Duka. Importantly, Pillay does not share with this court exactly what he means by in the vicinity of Florida Road. And by that I mean nowhere in his affidavit does he state where the cell phone records place an individual 5 meters, 50 meters, 100 meters, 500 meters, or even 1,000 meters away from any particular spot. The investigating officer adopts a similar modus operandi in respect of other geographical places in which he relies on virtual cards without ever having investigated how many individuals were issued with the virtual card or how accurate the cell phone triangulation is. Instead, he prefers to rely on in the vicinity. Ad para 31. Once again, the state relies upon the fact that applicant 1, 2 and 5 were placed in the vicinity of my home on 11 February 2023. In this regard, I deny that they were with me, but I was most certainly at my home. I cannot comment on what applicant 1, 2 and 5 were doing or where they might have been. In this regard, it is significant that the other applicants have been charged with various offences in their own capacity or where they are linked to each other. That they knew each other and may have been participant in other activities, I am not in a position to deny, as I do not know. Importantly, I have not been charged with any other offence besides this one. This is significant in that Pillay has alleged that the applicants are a gang and are available for hire. This is not, even on the state's version, the evidence before this honourable court. Ad para 33. I note that Pillay has elected to attach a table, Annexure KP1, to his affidavit, rather than simply attaching the actual bank statements, which would give this honourable court a proper insight to the passage of monies into and out of my account. Ad para 38. Pillay once again jumps to conclusions when he alleges that I gave instructions for the disposal of the vehicle, referring to the grey BMW. This is a distortion of the truth in that I did not dispose of it in the sense of wanting it hidden, as Pillay wants this court to infer. at para 48. Yet another example of Pillay not wanting to take this honourable court into his confidence is his reference to the raiding of my home. He states, entry was gained in a lawful manner as usually used when looking for suspects in order to arrest. What does this mean? He does not take the court into his confidence and describe exactly what occurred, and that is that heavily armed policemen forcibly gained entry into my home, and this was unnecessary. In this regard, I annex here to marked GR1 video footage of the said raid, and Your Worship, I understand that that is in the USB attached to the brown envelope. The actions of the SAPS are particularly alarming when it is alleged that a member of the SAPS team apparently spoke to me personally on 26 February 2024. See paragraph 207. At paragraph 118, Pillay states that there is evidence suggesting that the applicants operated as a gang that were hired to kill people as hitmen. Yet again, he does not take this court into his confidence and disclose what that evidence is. But the fact of the matter is that although he mentions that the applicants are at present facing, it should be facing, Your Worship, 12 counts, I am not. Once again, he does not disclose to this court why he has not arrested Gwabeni, more especially in light of his theory that I was hired to kill people as part of a gang of hitmen. At paragraph 119, as stated herein above, yet another example of the vagueness and smoke and mirrors that the state has brought to this investigation and this application is the following statement on the part of Pillay. There is an element of evidence suggesting offences committed under gang-related activities. The state is collecting evidence to substantiate these charges. He does not explain what an element of evidence is, which suggests offences, but simply states that the state is collecting evidence to substantiate these charges. The inference to be drawn is that this is yet another theory lacking in evidence. Similarly, the statement that there is evidence suggesting that there were discussions falls into the same category. At para 136, the state has alluded to money laundering and the proceeds of crime in respect of the 800,000 rand. He also makes mention of the reference in the bank statement to consult or consulting. He appears to have lost sight of the fact that that would have been a reference that was given by the person or entity that deposited the money and not myself. Once again, if the state is so confident that these monies were for unlawful purposes and it was not for consulting, then the state must explain why they have not arrested the individuals who deposited the money. In this regard, I annex here to marked GR2, a statement issued by Mandla Gwabeni in respect of the said monies. As for the reasons given as to why the state opposes bail, the state alleges that I will endanger the safety of the public or will commit further Schedule 1 offences because I am the alleged mastermind and was involved in the planning, and that this is therefore indicative of someone who can pose a danger to the public. I am advised that what the law requires is a likelihood, i.e. the probability, and not whether one can, as opposed to the requirement of will or would. In respect of the allegation that if released on bail I will attempt to evade trial, the state relies upon the fact that they have no evidence that I pay towards the bond of the house I live in with my wife and children. It clearly has not occurred to them that often in a marriage one spouse pays for certain expenses while the other pays for the remainder. It is untrue to suggest, as Pillay has, that my wives would be able to fend for themselves without financial support. In this regard, I wish to remind this Honourable Court that my second wife is a student, and as such, she is unemployed. Her studies and indeed her entire existence is financed by myself. In respect of my first wife, as mentioned, the bond payments may come off her account, but I pay for the remainder of the other expenses. Were it not for my financial contribution, she will have insufficient funds to pay for the bond and maintain my family. Although my first wife is a practicing medical practitioner, she is also furthering her studies, and this is another financial commitment which needs to be met. Previously, this Honourable Court had ruled that the statements I had made and my analysis of the content of the affidavit deposed to by Elaine Harrison, the Director of Public Prosecutions for KwaZulu-Natal, had to be struck out as the court ruled that her affidavit was not properly before it. On the last occasion that this matter was in court, the learned magistrate allowed that very same affidavit to be admitted provisionally on the basis that same had been obtained from social media. I now take the opportunity to comment thereon. I deal with the content of Harrison's affidavit hereunder. In paragraph 9, Harrison alleges that Linda Kushle Ndamande was residing at my residence. She wishes the court to draw the inference that he was residing there and then left to go to Eswatini. Whilst it is correct that he did stay in my outbuilding for a brief period, he left some time ago, and certainly before the date of the shooting which led to the death of the deceased. It is my respectful submission that the state's case, certainly against me, is founded wholly on circumstantial evidence and manufactured coincidence. Mention is made of the deceased's entourage being followed by a grey BMW from the airport to the Hilton Hotel. It states further that upon further investigation of cellular phone records, it was established that I was present in the grey BMW. This is untrue. The airport and its vicinity is a national key point area, and as such there are numerous cameras. I challenge the state to provide video evidence that I was in the said grey BMW. Rather misleadingly, it is stated that it was also established that I had hired the grey Polo and that it was used as a spotter vehicle. I do not dispute that I hired a grey Polo with registration NUR 597782. I hired it from a rental company as it was needed for my business requirements. Unfortunately, this Honourable Court is not informed as to the fact that I hired the vehicle some 10 months before the deceased was killed. Prior to the 10 months, I had hired another vehicle from the same rental company. It is also significant that where the state relies upon cellular phone records to place individuals in certain vicinities, that at two of Durban's most popular areas are the main road in Mshlanga, where the restaurants are situated, as well as Florida Road and its vicinity. In respect of Linda Kushle Ndamande, it is alleged that he was a spotter. I have read in the media that it is alleged that he used his credit card in the Wish restaurant. As a result of this fact, it is alleged in paragraph 15 of Harrison's affidavit that he must have been the individual who got out of a grey Polo motor vehicle, no registration number given, because his clothing was the same as the individual later identified as Linda Kushle Ndamande. In essence, what has been alleged is that it must have been him who stepped out of the grey Polo, whereas there is no actual evidence to suggest that the person who alighted from the Polo was the same person who used his credit card in the restaurant. I wish to make it clear that I only comment on same because it is alleged that I acted in common purpose with my co-accused. I am therefore to an extent compelled to deal with some of the allegations pertaining to them. In paragraph 21 of her affidavit, she states that it was established that there had been an attempt to set a Mercedes-Benz alight by one of the suspects. She goes on to state that one of the suspects also purchased airtime from a tuck shop situated a few meters away from where the said vehicle was abandoned, and that investigations revealed that Sipa Mandla Ngobo was identified as the individual who recharged his phone with the airtime purchased from the tuck shop. There is no nexus between the individual who purchased airtime and the individual who attempted to set the vehicle alight, apart from the allegation of Harrison. In paragraph 22, Harrison makes the allegation that the cellular phone records obtained for Sipa Mandla Ngobo indicate that he was at the scene of the murder and communicated with me. Once again, it appears that the state is relying on circumstantial evidence, as there does not appear to be evidence of Sipa Mandla Ngobo in the Mercedes-Benz in question at the time of the murder. Once again, I remind this Honourable Court that the Chartwell Drive vicinity in the Mshlanga Rocks and Florida Road are considered Durban's nighttime entertainment areas. I am not in a position to recall whether Sipa Mandla Ngobo may have communicated with me on that day or not. If he did, it would most certainly not have been related to the killing of the deceased, and may in all likelihood have been related in my wishing to engage his services amongst others. I shall now deal with the allegation, certainly as stated in the media, that I received 800,000 Rand the day that the deceased were killed, and that I transferred 133,000 Rand to Linda Kushle Ndamande. Once again, the state is relying upon coincidence. The 800,000 Rand was paid to me by Bright Cycle in respect of consulting work that I had done. It is true that I did transfer monies alleged, as I had not paid the individuals concerned for some time, as the nature of my work is that supply of monies is not always constant and regular, but goes through lean months and prosperous months, so to speak. I annex here to my bank statement for the period in question, and this Honourable Court will note that the transfers are referenced. Included in that reference is wedding, as one of the individuals concerned was getting married, and I paid him an extra amount as a gift. I also wish to point out that I paid the individuals concerned over an extended period of time and not just on that fateful day as the state wishes everyone to believe. Finally, in respect of the case against me, the state has failed to allege any motive on my part for wanting both of the deceased killed. They are unable, despite all the circumstantial evidence and conjecture, to place a motive before this court. The reason for that is that I had no motive because I played no part in the death of the deceased, nor would I. Yet again, the state speculates when it refers to the fact that I have allegedly hired bodyguards for my and my family's protection, and that therefore my life might be in danger. Aside from the fact that the use of the word might does not satisfy the required case law in terms of probabilities, the learned magistrate presiding in this application, when he ordered us to unmask on our first appearance, stated that their safety is not an issue. There is no evidence to suggest that I would evade my trial, and in this regard, I have voluntarily handed to the authorities my passport. Much is made of the alleged failure to hand my cell phone to the police. This is untrue. When I went to Ladysmith on business, I forgot my cell phone at home. When I was contacted and arrangements were made for me to report to the police, I did not return home but went to the police. I am of the belief that the cell phone was taken by the police who raided my property, as the said cell phone has not been seen since. The police were informed of this prior to my bail application commencing. I respectfully submit that the fact that I surrendered myself to the authorities is a clear indication. It states I would evade my trial, but obviously it should state I will not evade my trial if released on bail. The state has alleged that if I am released on bail, I will influence or intimidate witnesses or destroy evidence. I deny the allegation and point out that the state's case against me appears to be based solely on formal evidence, i.e. cell phone records and locality, as well as flow of money into and out of my account. I deny the allegation that Caleb Naidu feared for his safety and as a result handed me a copy of his statement. It is simply not true. Ad para 234. The allegation that my attorney, when offering to make a statement about the grey BMW, was devious and calculated is far-fetched and without foundation. I was informed that the BMW had been seized and that the police were investigating same. It is only natural that I, as a law-abiding citizen, would have approached the authorities in order to explain how I came to be in possession of the said BMW. The allegation made by Pillay in this regard is yet another indication of the fact that his affidavit is scarce on facts and big on opinion. I am given to understand that an investigation ought to be objective and constitutionally sound. Pillay has fulfilled neither of the criteria. Ad para 235. The allegation that I disguised the money paid for the hit as a consultation is wrong. The annotation that a company did transfer of money into my account would have been done by the sender and not the receiver. Once again, I must ask, does the state intend to arrest Mfundo Gwaba? As for the references to dividends, car repairs, buying cars and wedding things, I am fully entitled to use any reference I wish. The simple fact of the matter is that the reference to dividends was the reward or remuneration for the services that I utilized. Buying cars and wedding things was for applicant 1 who was due to get married on 26 February. The state has alleged that there is a likelihood that I will undermine or jeopardize the objectives and the proper functioning of the criminal justice system because I allegedly run a security company that is not registered with SURA. I do not run a security company in the sense that I provide a security service for third parties. As such, there is no obligation on me to register with SURA, nor for those individuals that I make use of. The state makes much of the fact that I hired applicant 4 as a bodyguard in circumstances where he was declared unfit to possess a firearm. In this regard, I have never provided arms for any of the individuals, nor have I utilized the term bodyguard. Ad para 253. In respect of my private licensed firearms, they remain in the safe in my house, and I made the said safe available to the police. I have nothing to hide. Ad para 258. The state alleges that the proceeds of crime were deposited into his company account on 11 February 2023 as part of payment for the killing of the deceased persons. I deny that this is so, but based on the state's own version and the submissions of Pillay, the allegation made is defamatory as against myself and, more importantly, Mfundo Gwaba. As a consequence thereof, the SAPS either need to retract same or provide the evidence by arresting Gwaba. The failure to do so can only but mean that they accept that the monies paid into my account were not for the purposes of a hit, but was a legitimate payment for the work done. In conclusion, I respectfully submit that I have addressed each and every allegation, and that some of the allegations made by the state have already been negated by third parties who at the same time corroborate what I have placed before this honourable court. I respectfully request this honourable court to grant bail in the amount which is deemed appropriate, as well as the conditions deemed appropriate. Then, Your Worship, there's just 3 annexes that I also need to read into the record, and which are capable of being read into the record, if I may.
You may proceed.
Thank you. The first one is dated 31 March 2024. It reads, for immediate release. Statement issued by Mandla Gwaba on behalf of the Gwaba family regarding Mfundo Gwaba in an ongoing court case.
Let me get to that. I thought you were going to read the page immediately after the one. So you are skipping Precious Gwabeni, Yolanda Zondi statement. And
Sorry, Your Worship. I see that
Okay.
I have them in a different order. Would Your Worship prefer me to read them in the order that Your Worship has?
Okay, please.
Very well. So there's a confirmatory affidavit. First confirmatory affidavit reads as follows. I, the undersigned, Precious Bulelwa Gwabeni, do hereby make oath and state. I am an adult female medical practitioner. I am the first wife to applicant 4 herein. The contents of this affidavit falls within my personal knowledge and belief, both true and correct, save where the contrary appears from the context. I have read the affidavit deposited by Kumasaran Pillay and respond thereto as set out herein under. I depose to this affidavit in reply to the above mentioned. I have also read and heard the contents of the affidavits of Mzuatemba Harvey Gwabeni. I have read the above mentioned affidavit of Mzuatemba Harvey Gwabeni and confirmed the facts contained insofar as they relate to matters concerning me. Dated at Durban, signed on this day of April 2024. The second affidavit, confirmatory affidavit, Your Worship, reads as follows. I, the undersigned, Yolanda Zondi, do hereby make oath and state. I am an adult female, a law student at the University of KwaZulu-Natal. I am the second wife to applicant 4 herein. The contents of this affidavit falls within my personal knowledge and belief, both true and correct, save where the contrary appears from the context. I've read the affidavit deposed to by Tomatis and Pillay and respond thereto as set out herein under. I depose to this affidavit in reply to the above mentioned. I've also read and heard the contents of the affidavits of Mzuatemba Harvey Gwabeni. I've read the above mentioned affidavit of Mzuatemba Harvey Gwabeni and confirmed the facts contained insofar as they relate to matters concerning me. And that is also dated April 2024. The third annexure, to confirm that I'm literally and figuratively on the same page as Your Worship, that should be, it should start with for immediate release.
Yes.
Thank you. It's dated 31 March 2024 for immediate release. Statement issued by Mandla Gwaba on behalf of the Gwaba family regarding Mfundo Gwaba in an ongoing court case. Since the name of our brother Mfundo Gwaba was recently mentioned in court in the murder trial of Mr. Tabela Mochwana and the late South African music icon Kieran Jarrett Forbes, popularly known as AKA, there has been much speculation in the public domain about the reason for one payment that was mentioned by the prosecution. As the Gwaba family, we acknowledge the gravity of the situation at hand and the widespread interest it has garnered. We wish to express our unwavering faith in the South African judiciary and affirm our commitment to cooperate fully with all arms of the state in the pursuit of justice. In light of recent developments and the allegations directed towards our brother Mfundo, we wish to clarify the following. Mfundo is an adult and is a successful businessman involved in various sectors, including coal mining and the taxi industry. It is important to note that financial transactions between him and Mr. Gwabeni were purely for business purposes. These numerous transactions over a long period of time can be verified through bank records and were neither unique nor isolated. We are concerned that the authorities have not yet approached Mfundo to share his side of the story. We believe in the principle of fairness and the right to be heard, and we urge that this opportunity be extended to him at the earliest convenience. It is crucial to understand that Mfundo has assured the family that he has no connections to any illegal activities, nor does he have any motive to engage in such. His business dealings are legitimate and transparent, having nothing to hide to anyone, least of all our law enforcement. The Gwaba family take this opportunity to extend its deepest sympathies to the Forbes and Motrene families for the tragic loss of their children. It is a message we wish to extend to many South African families who lose their loved ones through violent crime that has afflicted our society. We express a sincere hope for a swift resolution to this case, allowing all affected families to find closure and healing. We appreciate the media's role in informing the public, and we uphold the right to a free press. We also request that our privacy be respected during this challenging period, and we commit to providing updates as more information becomes available and as appropriate. We stand united in our support for Mfundo and remain steadfast in our commitment to the rule of law. The family has since requested Mr. Jackie Shandu to respond to future media queries on its behalf. He can be contacted on, and it then gives a cellular phone number, Your Worship, and an email address. Your Worship will also note that with the affidavit of applicant number 4 are a number of still photographs, which I understand are taken from the USB, which is contained in the brown envelope. So, Your Worship, that is the affidavit of applicant number 4.
Thank you. Mr. Gwabeni, do you confirm the content of this statement read on your behalf into the record? Thank you. The statement is accepted into the record. It's marked Exhibit M. Will that be the case?
Indeed, Your Worship, that is the case for number 4.
Case for applicant number 4.
Worship, I was reading the affidavit in respect of applicant number 4. I'm just concerned with the paragraph at page 16, Your Worship, paragraph 48.
Page 16
Yes, Your Worship.
of the applicant statement.
Yes, applicant statement at paragraph 48.
Paragraph 48. I'm
Yes,
with you.
it indicates I annex here to my bank statement for the period in question, and this honorable court will note that the transfers are referenced to. I don't see any reference or any annexion in respect of those, the period that is being stated, my learned colleague here. It is the same issue from the respondents' affidavit that we have highlighted also, Your Worship, in respect of that. If my learned colleague can
Mr.
clarify.
Jefferson.
Thank you. My learned friend is indeed right, and I'm glad he's reminded me of that. It is true that there is no annexure attached, but my instructions are that same was referred to in the founding affidavit. So if the court wishes, they can simply ignore that sentence in the affidavit.
Am I understanding you to say that when I read paragraph 4, I should refer to the founding affidavit of the applicant, and I will find the statement there?
Yes, those are my instructions.
The biggest challenge, Your Worship, that we're having, we indicated as the respondents in our affidavit that there are certain periods, including January, February, March, that are excluded from the bank statement in our founding affidavit in respect of this matter. So if my learned colleague is saying that it is in reference to that, I don't know where to find that.
Yeah, but Mr. Kwega, the applicants have been alerted of this omission by yourself, particularly Mr. Chaba. They've been alerted. They cannot be forced to do as you wish.
Please is the court, Your Worship. Then we'll leave that for arguments.
Yes.
Thank you.
Yes, Your Worship. I can't take that point any further,
Yes.
and Your Worship will obviously have to take that point into consideration. But I think it's necessary to point out, and of course the state can subpoena the bank records in respect of applicant number 4, so they could go back as far as they wanted to. Thank you, Your Worship.
Okay.
I think there were dates that we arranged in respect of
Yes,
complying with the state.
we have come now to the stage where the applicant's case have been closed.
Family, Gwabeni tells the court that he has 2 wives. One is a medical doctor who is still studying, and the other one is still a student, and he has a house, he has businesses, he has children, and all those needs his attention. It is his responsibility. That is what he presented to the court as he is applying for bail. Family, do you think Gwabeni deserves to be given bail? Let's talk in the comment section, family. Thank you very much for watching to the end. Please like this video before you leave. Subscribe for my channel. I love you, family. Thank you. Bye.